what are some securities laws issues that you need to deal with in creating an SPV or RUV? Well, number one, the SPV or the RUV is raising money from people. So it is conducting an offering. Usually there's an underlying offering it wants to participate in, but it in fact is raising money from people. Anytime an entity is raising money from people, and it's doing so with equity securities like membership interest in an LLC or a partnership, generally it's conducting a securities offering. So it needs to have an exemption from the public securities offering laws. Usually SPVs and RUVs are going to use what's called Regulation D, which generally means that they're going to rely on what's called Rule 506B, and they're going to want to limit their offering themselves to non-accredited investors. Accredited investors. If they take any non-accredited investors, they would be required to provide those non-accredited investors with certain types of required disclosures, perhaps, certain types of financial statements that are audited or reviewed. So it tends to avoid non-accredited investors in those cases. And if it did, it would be limited to only 35 non-accredited investors. So usually folks that are setting up SPVs, whether by the company or just like a lead kind of angel or syndication person, they're going to be using Rule 506B, limiting the offering to only accredited investors. They're going to have to disclose to people all material facts about both the underlying transaction in which the SPV will invest, i.e. the tech company or the e-commerce company the SPV is going to invest in. So it needs to sort of, port over disclosures probably from those entities to people, since that will be the only asset. It will have to warn people the only asset of this entity will be one single asset that it's taking. There's a lot of risk. People can lose their own money. So it has to comply with what are called basically all the anti-fraud rules of the securities laws. In general, SPVs would have to avoid what's called general solicitation, so raising money, either through publicly known means or announcing it to the media, unless it's going to use what's called Rule 506C that allows general solicitation, provided that the SPV then verify or take reasonable steps to verify that people are accredited. And that's a whole separate topic. But in general, these are private offering deals where people are going to people with whom they have a substantive pre-existing relationship. They've known them for a long time or have done business together. They've qualified them as an investor by things like a questionnaire, an accredited investor questionnaire, and then they've had them sign investment agreements or subscription agreements or other documents acknowledging the risk inherent in this type of deal. So those are usually the kind of securities issues that are at play. Now, there are other securities issues which we'll get to in another topic if there are going to be things like management fees and other things. But those are, if there is no management fee of any kind, then an SPV or an RUV, at least at a minimum, has to deal with those security issues. And by the way, when it invests in the operating company that it's considering for an investment, it will also have to make certain representations and warranties to the company that it's an accredited investor. And when you're an entity, one of the only ways to become an accredited investor is if all of your owners are also accredited investors or the entity itself has enough assets. So it's really important that SPVs and RUVs do limit, in general, their investors to accredited investors to be able to, in turn, make the kind of standard reps and warranties that companies ask for from those types of SPVs.